Good evening, everyone. It's my great pleasure to be here in Brazil and this city of first in Rio and then in Fora. So I'm very grateful for the invitation, and I'm very pleased to be here and enjoyed very much the time that I've spent here in Brazil. When my fellow panelists, we were discussing that how should we structure this panel, they invited me to start. I think that was their first mistake. Because we professors, we don't stop. Because unless it is the time for the lecture to be finished, we have to complete it. The second mistake they did, I think, is they asked me to critique the guiding principles. And if you ask me to critique the guiding principle, that is likely to take a long time. So that was the second mistake. But anyway, jokes apart, in the brief time that we have, it's about 20 minutes for each one of us, I hope to achieve 3 objectives. My first objective is to highlight the historical contours of the area of business and human rights very briefly. The second objective that I have is to offer very brief critique of the guiding principles, because that will justify why do we need to move forward and do something more than the guiding principles. And finally, I will offer some signposts for the future of the BHR, what particular aspects we should keep in mind. Now, the discourse of business and human rights, in my view, is as old as the institution of corporation. Many of you may be aware of the fact that the British East India Company was established in 1600. And that was the company that the British Empire did use to colonize many places in Asia, including India, from where I come, and including the place where I'm located now in Hong Kong. The British East India Company indulged in what we will consider today as violation of human rights. They employed child labor. They exploited the farmers to grow opium in India and then export it to China, and so on and so forth. But of course, in concrete terms, we started identifying BHR, but I very much liked the center, human rights first. So people don't call it business and human rights, rather you call it human rights and business. So I personally favor this. But the discourse is more or less identified as business and human rights. I'm going to use it BHR for the sake of convenience. So the BHR discourse, in my view, the engagement of the UN and the regulation at the international level, in particular at the UN level, can be divided, in my view, in the 4 broad stages. The first stage was in early 1970s, when an attempt was made to create a code of conduct for transnational corporations. This attempt continued till 1990s, but it could not succeed. And one major reason why it did not succeed was the conflict between what we regard as developing countries and developed countries on the other hand. There's also kind of a conflict between what should this code be all about. Should we focus on the rights of the multinationals operating in the global south as we know it, or should we be focusing on more on the obligations, on the responsibilities of the TNCs? The second phase, in my view, could be towards the end of the 20th century, 1998 onwards, where a subcommission was created, a working group was created to draft what we know as the draft United Nations norms on the responsibilities of business enterprises. And then in 1999, Kofi Annan, the formal Secretary General, launched the idea of UN Global Compact. So that is, in my view, the second phase. The norms were drafted in 2003, but of course, they received a tremendous amount of opposition from business actors and many states, and they could not be adopted. So that sort of summed up the second phase of the TNC regulation. Then the third phase, in my view, started with the appointment of a Harvard professor, Professor John Ruggie, and I'm sure many of you working in this field may know. So his appointment in 2005, in my view, was the third phase of UN regulation, This mandate continued for 6 years, and it culminated in the adoption of by the UN Guiding Principles on Business and Human Rights, which were endorsed by the Human Rights Council in 2011. The fourth and the final phase, in my view, started with the initiative which was led by Ecuador and also supported by some other countries in Latin America and in Africa in particular. Supported, of course, surprisingly by India and China. Surprisingly, I can discuss later. And this initiative, in my view, had started, and my colleague Carlos is going to talk more about the treaty process, which will begin in July this year in Geneva, so I'm not going to talk about that. But what I would like to highlight is that this current fourth phase of the attempt to regulate companies, in my view, is very critical, and it is very different from the previous phases. One thing, in my view, that stands out is the role of civil society. We are talking about creation of international law. But what is very crucial is that the international law creation push is led by civil society, which are non-state actors, which is very unique. States are, of course, leading, but the push is coming from civil society, which is a remarkable change in the discourse, which was not visible in the first three phases that I have highlighted. They were more driven by either academics or driven by the states, which is, in my view, is a critical point, because I see international law in the 21st century has to conceive itself beyond the state-centric idea of international law, both in lawmaking as well as in enforcing these norms. In my view, that is very, very critical. Now, moving on to the second objective, I will very briefly talk about the guiding principles and especially the limitations of the guiding principles. Let me start with a disclaimer that when I'm critiquing it, I'm not saying they are not useful. Guiding principles are definitely very useful instrument. But as an academic, my role is to challenge the limitations of the instrument that we have and also highlight that why these guiding principles are not going to be enough to tame the corporate power when it comes to the human rights implications. I'm going to go through a couple of points in terms of the critique of the guiding principles. My first point is about the driving principle, which was adopted by Professor Reggie. His driving principle was principled pragmatism. So there are two words here, principled and pragmatism. This was a very clever choice, combining these two, which is something similar to sustainable development. So what you see here is kind of a contradiction between being principled and being pragmatic. Can you do both? Very difficult, right? It is very difficult to concentrate to listen to me and listen to the music outside. So there was a good timing. It's very difficult to strike the balance. And that's why, in my view, though the term, the theory he came up with was principled pragmatism, it was more pragmatism, less principled in terms of the human rights. Human rights became negotiable instrument when it comes to their application to business. We'll come up with the guiding principles which are going to be acceptable to the business. So ask the business actors what is going to be acceptable to them, and whatever is the consensus in the business community, because otherwise it will not work. And that's why that is my first problem with the guiding principles. The second difficulty is the normative basis. Why should companies have human rights, responsibilities, or obligations? The response of guiding principle is that there is a social expectation. I have a significant difficulty with this term, social expectation. How did he or those who drafted these guiding principles know that these are the social expectations? Because many people expect businesses to do more than what the guiding principles are talking about. The social expectations can vary from place to place. They can vary from company to company. Social expectations can change. What were the expectations yesterday may not be today, and what will happen in future may change. So this is a very amorphous and weak normative basis to root the human rights obligations of companies, in my view. The third difficulty that I have is those of you who may know the guiding principles, they are based on three broad pillars. The first pillar is the state duty to protect human rights, which basically means that the state entities should ensure that the corporate actors operating within its jurisdiction or territory should not violate human rights. That is the first pillar in short. The second pillar is that the companies have a responsibility to respect human rights. I would like to highlight the words responsibility and respect. When it is first pillar, it is a duty, which is considered an obligatory responsibility, if I could call it. But when it comes to companies, it is not obligatory. It is not legally binding. It is merely a responsibility. The second difficulty with second pillar is that here the focus is merely on that they should respect human rights. Those of you who may know international human rights law, the tripartite duties are very well established. When it comes to human rights, the obligations are threefold. Respect human rights, protect human rights, and fulfill human rights. Now what the guiding principles do, they pick up one out of these three core aspects of human rights. They pick one for the state, they pick one for the companies. That is highly problematic. Because when it comes to the responsibility or the obligation of a state to ensure that the companies do not violate human rights, in my view, the respect category of obligation as well as the fulfill category of obligation is equally relevant. Guiding principles ignore that because they frame it in terms of the duty to protect only. Of course, when it comes to the second principle, here the focus is again only on respect. So the protect and fulfill aspect becomes irrelevant. Now this becomes very crucial in the context of the global south, where socioeconomic rights are violated by these companies and merely respecting these rights may not be enough. If we have a company operating a mine in a distinct community where access to road, electricity is not there, then we cannot simply ask the company merely not to violate human rights. I give you a concrete example. I went last year in a workshop which was again funded by the Ford Foundation in a mining state in India. The land of farmers was acquired to build this electricity plant with a huge capacity. It's about 1200 mega power electricity plant. But the farmers who were living in small huts across the power plant did not have electricity. So the electricity that is being produced on the land of these displaced farmers do not have access to electricity. So what kind of framework we are talking about in that particular sense? The last 2 points about the critique. The guiding principles very cleverly bypass or put under the carpet the controversial issues. They try to build consensus, in my view, on issues where there was hardly any controversy. So when it came to the issue about the liability of a parent company for the violation done by its subsidiary, they merely acknowledge this as a difficulty. Any student of law would say that. But if you are expecting something more, in my view, from a Harvard professor, because you're trying to drive the agenda. So you can't simply say that this is a limitation which is there. You need to come up with a solution. What are the options? How could we overcome this particular issue? My last point about the critique is that the guiding principles will not work in hard cases. Our vice rector did borrow from Dorkin. I'm going to borrow Dorkin again for hard cases. What I mean by hard cases in BHR, hard cases are those cases in which states are either not willing or they are incapable to go after against the big multinational companies or even domestic companies, or those situations where the business actors have no interest to comply with human rights norms. Guiding principles would hardly be of any use in these hard cases. And that, to me, is a significant limitation. If you are expecting a company which is already kind of a nice company, willing to do something for the community, you don't need guiding principles for that company. You need guiding principles. You need binding regulation for those companies who say human rights have nothing to do with us. And guiding principles or situations. I'm based in Hong Kong, which is part of China. Now, if you expect that the Chinese government will ensure that the companies operating in China will not violate human rights, I think that is too ambitious. This expectation, and that's why the pillar 1 goes to the rubbish bin in those situations. It is totally irrelevant because you cannot really expect certain states to take care of those particular situations. I will stop here about my second objective for today. Now let me move on to the last objective for my today's talk. That is about looking at the future. And in my view, what key variables should be kept into account while developing the business agenda in future, BHR agenda in future. The first is binding international regulation, in my view, is very, very critical. Binding regulation is also effective because the voluntary approaches work better under the shadow of binding regulations. So if we know that there is a stick here, carrots work better if there is a stick behind carrots. If you merely have carrots on the table and there is no stick around, people will take the carrots and run away. And here I'm referring to incentives and disincentives. And that's why stick is very critical. The second point I would like to make is that in the 21st century, we need to look beyond a state-centric framework of human rights law. And I see very positive signs where universities could play a very critical role in making companies accountable. Civil society can play a key role in making companies accountable. Trade unions, so these are not part of the state machinery in the formal sense. So we can use non-state actors. We can use informal means. We can use social sanctions to make companies accountable. And in my view, that is going to be very critical component of the corporate regulation in the next few decades. The third point I would like to highlight is the voices from the global south. What has been happening is that the agenda is set by the north, and the global south has been following that agenda. I think it is very critical that the voices from the global south are heard. And those voices are not merely heard, they are setting the agenda, not merely for the global south, but for the whole world. The time has come for the global south to rise and let its voices be heard. Not to replace the global north, but to work together with global north and make this work. The last point I would like to make is, which is very ambitious, but in my view is very critical. We have to question the fundamentals of free market economy. Some of the business and human rights issues are rooted in the very idea of free market, maximization of profit, what amounts to economic development and all this. These are very, very critical issues. And in my view, the future discourse of BHR should be willing to question and challenge these assumptions. Thank you very much for your attention. I'll be happy to take questions or comments. Thank you.